Well, welcome, ladies and gentlemen. My name's Harry Bruce. I am the Dean of the Information School here at the University of Washington, and it gives me a great pleasure to welcome you all here to this colloquia series that we are calling The Unintended Consequences of the Information Age. I welcome you on behalf of the Information School, or iSchool, and also the co-sponsors of this event, the Pacific Northwest Center for Global Security and the Scheidler Center for Law, Commerce and Technology. And it gives me a great deal of pleasure to hand over now to a colleague of mine, the Dean of the Law School, my friend Joe Knight, who was going to get us started. Joe has been with the University of Washington for about 4.5 years now, and during his stewardship of this wonderful school, he's seen his team move into the glorious building, the William H. Gates Hall, a wonderful signature building of the University of Washington. Joe is an expert in commercial law. He's written 3 books on this topic. I hear that they're all bestsellers and darn good reads. So we'll get the titles of those a little later on, Joe, and make sure that everybody gets to read those. But without any further ado, please join me in welcoming Joe Knight.
Thank you, Harry, and good evening to all of you. I'm really delighted to add my welcome, along with Dean Bruce's welcome, to each of you, and my thanks to each of you for joining us here this evening for this wonderful colloquium. This is the second in a series of colloquia that really address the point-and-click generation. And so we're going to have a great group of panelists here tonight that are going to talk about some of these issues. And we're going to lead it off with our State Attorney General, Rob McKenna. Now, Rob is a UW alumnus. He graduated in the class of 1985. He then left the state of Washington and went for his legal training at the University of Chicago and graduated from there in 1989. He then returned home, has done a host of different things, working in a law firm, and in 2004 decided that he was going to take this wonderful step into public life and run for the Attorney General's position. He has done a remarkable job. As a lawyer, I can tell you that there are very few attorneys generals in our country who are more well-respected or as well-respected as Rob McKenna. And he has particularly left and begun and left his mark in this area of privacy. So without any further ado, it gives me great privilege and pleasure to introduce my friend, Rob McKenna, our Attorney General for the state of Washington.
Thank you, Joe. I appreciate it. First of all, thanks to Kirk Bailey for inviting me to be here. Joe, thank you very much for your kind introduction. I have found that one of the highlights of my first 17 months as Attorney General has been the opportunity to collaborate with Dean Knight and the University of Washington Law School, with Kirk Bailey and his colleagues in computer information security, the CISOs of our region. They've just been terrific to work with. Tonight we're going to hear the voices of several individuals who have come at this topic from many different angles, a different angle in each case. We will hear from a woman who took her personal fight to be free from cyberstalking from Olympia to Washington, D.C. We'll hear from an attorney who worked to defend a client's right to freedom of speech on the internet. We'll hear from a woman who, in serving as general counsel for a large medical organization, took civil action to catch an online criminal. And we'll hear from a longtime federal prosecutor who's worked for many years at illuminating wrongdoings that are perpetrated using high technology, including the internet. The goal of tonight's forum is to engender a discussion so that we as a community can more effectively turn our collective and individual attention to dealing with the problems that technology can create as, again, an unintended consequence. Among all of us, there are those who are here tonight and who are watching here tonight who are consumers of technology, but also there are some who will be hearing from tonight who became a victim of the unintended consequences of the point-and-click world. For Joelle Ligon, who you'll hear from tonight, it took years of work to figure out a number of creative ways to deal with an online stalker. She had tried everything. She tried ignoring him, confronting him directly via email, reporting him to her employers, reporting him to the police. She was stalked by an ex-boyfriend for 5 long years, during which this to other people, faceless, nameless stalker posted her personal private information online inviting men to call her for sex, making baseless accusations about her professional and personal life to coworkers, making her feel unsafe in her own home. Almost everywhere she went to for help, they didn't know what to do to help her. Not because they didn't care, because they didn't know how to help. They didn't know how to help her because her problem was one they hadn't heard of before at this time a few years back. This is the case for many of us in the community, many of those in the community who have become the victim of online free speech. They don't know how to stop the problem once it starts, or even who to go to for help to get it stopped. These are examples of unintended consequences. The other side of this same debate, of course, is freedom of speech. Since the founding of our country, since the adoption of the Bill of Rights of the Constitution, freedom of speech has been something we've held near and dear. Organizations like the American Civil Liberties Union and the Electronic Frontiers Foundation continue to work hard to ensure that this basic right is protected. It's a complex issue that will not have simple solutions when questions are raised about where free speech crosses over into abusive speech. It seems to me that all of us have a responsibility to engage in the debate, in the discussion about where free speech begins and where it ends, and abusive speech begins, and what we're going to do about that. Tonight, you have a fantastic array of speakers to address those very questions. I'm honored that I was asked to come and speak here at the beginning to talk about some of these issues as we're working on them in the office. Look forward to hearing the other presenters this evening, and I thank you very much for your attention tonight.
It is my great privilege now to introduce Guy Nelson, who is the KUOW News Director, and Guy is going to serve as our moderator for the remainder of the evening. He's got a great series of questions, and as the Attorney General has already mentioned, we've got a wonderful set of panelists. I know that you're going to be stimulated by the discussion, provoked into thinking differently, and maybe we can actually come up with some ideas about how we can address some of these thorny issues. Guy.
Thank you very much, Dean Knight. It's my pleasure to be here as well and to welcome all of you to this very interesting program. We have a very distinguished panel with different points of view on this topic, and I look forward to hearing a very lively, spirited discussion. So let me introduce our first panelist this evening. She's Joelle Ligon, and as you have heard, she is a former victim of cyberstalking. Through her ordeal, Joelle became a staunch advocate for victims of cyberstalking, working to create the first cyberstalking law in Washington State. She was also the force behind the recent change in the federal cyberstalking law, and she has worked to raise awareness of the crime of cyberstalking and its impact on victims. Her efforts have led her to appear in both the national and local media, including appearances on Good Morning America and in People magazine. So please give a warm welcome to Joelle Ligon.
Thanks for coming tonight. My name is Joelle Ligon, and I'm going to share with you my personal story of cyberstalking. I met Jim in 1984 in Salt Lake City, Utah. I was 15 years old, and Jim was 18 years old, and Jim was my first boyfriend. We dated for 7 years, and we broke up in the early 1990s when I was in my early 20s. And our breakup was like many breakups. It was sometimes hostile, sometimes amiable, and in the end, we did actually stay in touch for a few years after we broke up. And by the time Jim started stalking me in 1998, we had not seen each other or spoken to each other in about 7 years. And during that time, during those 7 years, I had moved to another city in another state. I had been married and changed my name and changed many addresses and many employers. But all these changes in my personal life didn't stop him from being able to find me, actually, quite easily. In the spring of 1998, I was working in Chesterfield County, Virginia as a public information officer for county government, and I got an email from a woman who was calling herself Courtney Collide. And Courtney said that we had known each other. At one point, we were waiting tables together when we were younger, and she gave me a sort of a grocery list of details about my personal life that made me believe that I knew Courtney. And I was very embarrassed. And I wrote Courtney back and I said, I'm sorry, I don't remember anyone named Courtney, and I don't remember ever working with you. Can you tell me when we knew each other? And Courtney wrote back with more personal details about my life, but nothing about her. This email exchange continued through 2 or 3 emails until I just became frustrated and angry and said, I don't want to have any more contact with you because I don't know who you are, and this is just strange and creepy. But that didn't stop the conversation. Courtney continued to send me emails over the next 18 months, which were just a series of invitations to have a conversation online, to become friends online, to become pen pals online, and constantly feeding me information about my personal life, information about where I had my mortgage, the name of my husband at the time, my home address, my telephone number, the name of the building that I worked in. And I was becoming increasingly agitated, but there wasn't really anything that this person was doing that was illegal or wrong. It was just strange and weird and creepy. And then in September of 1999, I got my first middle-of-the-night phone call. And what happened is that Jim went into a chat room and impersonated me, invited this other person, this young man, to call me at home. He gave out also the name of my husband at the time, his name, and called us at home in the middle of the night to try to get together that evening to have sex. The next day, I went to our local police in Chesterfield County, Virginia. After a short investigation, they discovered that he lived out of state in South Carolina. We were in Virginia, and at the time, he hadn't broken any laws. The investigation seemed to stop the emails, and so I was satisfied, and nothing ever came of that. And what happened in the coming years was that it wasn't over at that point. What I realized is that there had begun to be a pattern that was set up, and the pattern was that he would send me emails introducing himself as a new character, as though I had forgotten what had just happened in the months prior, inviting me into an online friendship, inviting me to have a conversation with him online, to be pen pals, to be close, feeding me personal information, new information, old information about myself. And then when I did not respond, he would become increasingly agitated until he would do some sort of big finale, which would be something like the middle of the night phone call. And this went on until July of 2002. And it was something that I decided that I could live with because I was not able to stop him. It wasn't that bad. I wasn't being put in harm's way. And I thought that eventually he would stop. But in July of 2002, things actually started to get worse. By that point, I had moved out here to Seattle, Washington. I was going through a divorce, and I had changed jobs at least twice, changed addresses several times. And he began posting my work information online on message boards during the day and inviting men to call me in my office to get together to arrange for sex, men in the Seattle area. And that was particularly disturbing to me. He also sent emails to my coworkers making it look as if there was some official organization from my alma mater which was sending out sort of a public service about how I may not have received my degree, how I have lied. I probably had lied about my professional qualifications. He sent emails to my coworkers with pornography that made it look as though it had come from me. So he was engaging in an actively harmful campaign against me in my workplace, and it began to be something that I simply could no longer ignore. And in the fall of 2002, the Chief Information Security Officer for the City of Seattle, who is now the Chief Information Security Officer for the University of Washington, Mr. Kirk Bailey, introduced me to listen to my story and introduced me to a local prosecutor, a local King County prosecutor by the name of Ivan Orton. And Ivan said, the first thing he did is he handed me the stalking statute in the state of Washington, and he said, there's nothing that has been done that's illegal, but the least I can help you do is I can help you find the identity of the person who's doing this to you. I had suspected from the very beginning that it was Jim because of the type of information that this person had about me, but I didn't have any proof. I had no way of knowing if it was actually him that was doing this to me. So we were able to confirm the identity, and based on that, the local King County prosecutor helped me get my case in front of the federal prosecutors in the Western District of Washington. And in January of 2003, the FBI opened an investigation into my case. Naively, I thought, oh, well, this is good, it's over, something is now going to be done. But in reality, this was just the beginning of a 15-month investigation. And 5 months into that investigation, the FBI, or excuse me, the federal prosecutor went with me to the local courts to get a restraining order, because up until that point, I didn't even have the luxury of going to a court and getting a restraining order, because I couldn't just walk in and say, I'm being stalked and harassed online, and I think it's that guy. That just would not have flown at all. But with the support of the federal prosecutor behind me, we were able to do that, and I did get a 73-year restraining order against him. And the investigation continued, and it was very difficult and long and protracted. And one of the reasons that it was difficult, long, and protracted was that the federal judges and magistrates in South Carolina would not give us access to his computers. They said that they thought that what was happening to me was unfortunate, but there was really nothing that they could do, and they frankly didn't think that it was the job of the federal government to get involved. Finally, in April 2004, Catherine Worma, a federal prosecutor in the Western District of Washington, was able to put together a 26-count indictment. He was indicted in July of 2004, and incidentally, when he came for his arraignment, that was the first time that I had seen him in over 7 years in the courtroom. And in July of 2004, he pled guilty. In October, he was sentenced, and he got 5 years probation, 500 hours of community service, and he pays $12,000 to my employer in restitution. So the reason I gave you this timeline is to show you that it took 6.5 years from the time that I got the first email until the time that he was sentenced. It was a distance of over 3,000 miles. It included 3 states, at least 3 local jurisdictions of police officers involved, and a federal investigation to finally get a prosecution and a guilty plea. As I mentioned before, I work for the City of Seattle. I work for government. I work for the City of Seattle Parks Department. When we build a new park, we go through an environmental review called Crime Prevention Through Environmental Design, CPTED. And what this is someone from the police department will actually look at our park designs and say, well, those shrubs are too high. Someone could hide behind there and potentially jump out and pounce on someone, or that's a dark corner back there. That's a good place to do a drug deal, or this is a blind corner, it's unsafe. So we build the park in a way so that users can feel safe. We all know that the internet was never built to be used the way that it is now. And as a result of that, it's rife with dark alleys. If I'm going to commit a crime against you, I'm not going to do it right here in front of everyone. I'm going to wait until the room is empty and it's dark and no one can see me, and that's when I'm going to commit the crime against you. And that's the problem with the internet, is that there are dark corners and dark alleys everywhere. So I know that we cannot legislate behavior. However, if laws are strong, and particularly the federal law is strong, at least victims will have tools to fight back, and at least perpetrators will have consequences for their actions. And that's all I have. Thank you very much.
Thank you, Joelle. And with that, I'd like to welcome our next panelist. Elena Luisa Garella is a graduate of the University of Washington Law School, class of '93. Her practice involves a wide variety of civil litigation, but her strongest area of interest is First Amendment rights, in particular, the protection of First Amendment rights on the internet. Cases of note include Sheehan versus Gregoire, striking down state statute prohibiting the release of identifying information of police officers as unconstitutional. King County versus Sheehan, holding that the Public Records Act does not exempt disclosure of the full names of police officers. Berger versus City of Seattle, striking down rules of the Seattle Center requiring performers to obtain licenses for performances in the public park. And Trummel versus Mitchell, striking down portions of an anti-harassment order that limited the content of a website. Please welcome Elena Luisa Garella.
Thank you. Thanks very much, and I'm very pleased to be here. It's a fascinating topic. It's something that I've worked with in my law practice for about the last 5 or 6 years, and it seems to come up. This issue seems to develop in a lot of different areas of social interest. So George Bush stated, and he was mocked roundly for a statement that there ought to be limits to freedom. He was talking about an internet site that was making fun of him back in 1989. And in fact, maybe not with respect to that internet site, but generally there are in fact limits to freedom. I want to bring up some of the legal tools that people who are victims of internet harassment in particular might have to address some of their problems. And the question for us tonight is whether these are adequate and sufficient, and if they're not adequate and sufficient, whether or not we can think of ways or start moving towards ways to improve the toolbox that's available to the person who's been victimized. The first one, defamation. It's a tort to, with malice, make untruthful and humiliating statements about people. Threats, true threats, are things that, statements that would be reasonably interpreted as being signaling the person who's made the statement's intention to do violence onto you. Invasion of privacy is another tort. And again, we're talking about civil suits when you are going to try and sue the person who's harassing you after you've figured out who it is. There are anti-harassment statutes which bring in the force of law, where you can go into court and get an injunction to stop the person. Of course, an injunction is only as good as the person who you're stopping's respect for the law is. If they don't respect the law to begin with, it could actually make them more upset. And then there are cyber-stalking laws, which have been passed federally and in most states. And then I just wanted to discuss very quickly a law that I've been very troubled by. I've had quite a few clients who have been the subject of anti-harassment orders. Here in Washington State, you can walk down to the district court and get an anti-harassment order fairly easily. There's essentially no fee. Your anti-harassment order lasts about 2 weeks until you get the person you're complaining about back into court, and then it can be extended to a year, and under some circumstances it can be permanent. What unlawful harassment, to get one of these orders, is you just have to show that there's been conduct directed at you which seriously alarms, annoys, or harasses you, or is detrimental to you, and serves no legitimate or lawful purpose. And again, there's that objective test. A reasonable person would have to feel the same way. The law throws in the language, constitutionally protected activity is not included, which is marvelous, except that in my experience, I believe that a lot of judges, particularly when constitutionally protected activity is intermixed with pretty bad behavior, kind of throw the baby out with the bathwater, and they stop the person who's not even before them in this court, at least on a temporary basis, and often on a permanent basis, from making statements that are well within their free speech rights. For example, in the recent case that went to the state Supreme Court, my client, Mr. Trummel, was writing a website about his former residence in a home for people over the age of 65. It's a federally subsidized housing project. And he wrote very unpleasant things about many people. And he also, according to the courts, did unpleasant things. In other words, conduct, such as yelling at people in the face and seeming to be threatening and frightening them. But the court said, not only can he not come within 500 feet of Council House, which is an enormous area, but also that he would have to strike some content off of his website, names of people, and that he wouldn't be allowed to contact other people. So it really came in very broadly, and ultimately the state Supreme Court cut out portions of the anti-harassment order. But going to the state Supreme Court is a long road to travel to protect your First Amendment rights. My concern as a First Amendment attorney in looking at these laws is the question about whether or not the courts are going to stick to the exceptions that have been carved out of the law with respect to free speech. In other words, the categories we discussed earlier, such as true threats, or whether this is defamation. I do believe that there is a tendency in the rush to protect people to start being a little bit sloppy about the application of the First Amendment law. And that's really my concern. I'm wondering if there would be possible to develop tools to address the kinds of situations that we've heard with Joelle without causing significant inroads into First Amendment freedoms. I suppose one thing that I've been thinking about with respect to the internet is, how is the internet truly different from other forms of media? Bad behavior has always been with us, and it always will be. I've dealt with cases of terrible stalking, not me personally, fortunately. I haven't been the victim of that experience. But in my legal practice, terrible stalking that it did not involve the internet. Anonymous phone calls, Xeroxed broadsides spread out around the neighborhood, horrible, abusive letters sent anonymously through the U.S. mail. So, in other words, these kinds of behavior exist outside of the internet as well as in the internet, and simply because a new tool is used, we should consider whether or not new rules should be developed or how those new rules should be developed. So in that way, I don't see the internet as being that much different than traditional forms of communication. Another difference people talk about is the anonymity. Again, anonymous communication has always existed. When they developed the printing press, followers of Luther, would write up anonymous broadsides against the Catholic Church and print them up, and that caused a lot of very angry persecutions by the government. The question of access by minors, that's interesting. These minors can now get right in the middle of this huge media stream. And as pointed out earlier, minors have always been subject to predatory behavior by strangers. So that has not exactly changed. But there are things that have changed. One thing is the spontaneity and the immediacy of this medium. Anyone who has ever sent out a message through email in the heat of the moment knows what I mean. Here you've written something that you really regret, and it's gone out over the wires, and it's permanent. The person who receives it might save it forever and forward it to their friends for additional amusement purposes. We've all seen those things. So there's the possibility with the internet of creating a printed document spontaneously and distributing it immediately. There's a question of whether or not questions of privacy have changed. I think in some ways they have, because in the past, if I wanted to get someone's social security number, I would probably have to do a fair amount of legwork and go down to the King County Recorder's office and deal with some musty old files, and now I can pull it up in the comfort of my living room and do something unpleasant with that social security number. There is the ability to drag up information and then disseminate it much more handily with the internet. And then there's the geographical range factor, which is very interesting and has a lot of legal implications because, as Joelle's story points out, someone can stalk you, not necessarily even from North Carolina, they could stalk you from the Ukraine if they chose to. And our laws are set up, policing is generally done locally. Our police force and the way we set up our country with municipalities, counties, states, and the federal government comes out of the 1700s. And it was very unlikely that in the 1700s someone from Virginia would be stalking someone in Rhode Island. So we essentially don't have we have jurisdictional problems, not only with getting matters investigated, but also with prosecuting them, because the federal courts don't tend to see themselves as the proper venue for relatively minor crimes, comparatively minor crimes. So ultimately we have with the internet also a medium in which someone who has no money can potentially communicate with millions of people. In the past, if you wanted to write up an anonymous pamphlet and broadcast it widely, you really had to have quite a bit of money to spend. And then if someone didn't like what you said, they could sue you, and you likely had some deep pockets to pay for the other person's pain and trouble. But here we have people who are absolutely poor and judgment-proof, who can say all sorts of terrible things and are essentially out of the reach of a judgment against them. I think it's a wonderful thing that impoverished people can speak freely to millions of people. The flip side is that in rare cases, the person who is outraged by a defamatory statement is unable to get any relief. I suppose ultimately in a discussion like this, I want you to consider the fact that human behavior is immutable. We're going to have bad behavior. There are millions of internet communications every day. I believe, I'm not sure, but I believe of the percentage of abusive ones is probably very tiny. And that's probably true of all human transactions and communications generally. It may behoove us to consider whether or not we need to amend our own expectations when we're dealing with the internet. It is a different medium. If you put up pictures of yourself drinking, and there's underage drinking going on, and you've signed an employment contract which indicates you won't tolerate that, and it appears on the internet, perhaps now that the internet exists, we have to consider our behavior a little bit more carefully. Or if my daughter or yours puts up things on MySpace that are unwise, she should be reminded that this is forever. That might pop up when she's running for senator in 50 years. So maybe it's not a question that the internet itself is dangerous. Maybe what's really dangerous is the fact that our society hasn't adjusted to the different expectations and the different realities that are posed by the medium. That's all I have.
Thank you very much, Elena. That was very interesting. I saw a lot of heads nodding out there as you made your final points. Our next panelist is Janine Sartee. She is the Regional Vice President and Chief Legal Officer for St. Luke's Health System, headquartered in Boise, Idaho. St. Luke's is Idaho's largest healthcare provider, which serves more than 325,000 patients each year from throughout Idaho and the 6 adjoining states. Ms. Sartee earned her bachelor's degree at Linfield College in McMinnville, Oregon. She received her JD from Gonzaga University School of Law in Spokane. Her professional bar admissions include Washington, Oregon, Idaho, and Colorado, U.S. District Court for districts of Washington, Oregon, Idaho, and the U.S. Supreme Court. Ms. Sartee has been an active participant in the region's legal community and has served either as a delegate, board member, or president of several professional associations. Ethics and responsible governance in healthcare have been a focus of much of her public speaking during the last few years. Please welcome Janine Sartee.
Thank you for inviting me to speak here today about the issue of cyberstalking and harassment, and thank you all for coming as well. The title of my presentation deals with the issue of corporate responsibility and protecting employees from harassment, or how we, as one organization in Boise, Idaho, used John Doe litigation to further our mission. About 2.5 years ago, I received a phone call from our Director of IT Security. He had indicated to me that there were 2 women in the IT department who did not know each other, that each received identical email messages that could only be described as obscene. So these 2 women, independently of each other, reported to their different supervisors that they had received this email message, which was describing certain deviant sexual acts that upset them tremendously. Their supervisors then reported to the Director of IT Security, who called me and wanted to know what, if anything, we could do to stop these harassing and obscene and threatening email messages from being received by these employees. Well, certainly there are a couple routes that we could take, and we did take within the organization. We have the ability, or our IT department has the ability, to block email messages that come from certain addresses, and we did that. My goal as Chief Legal Officer for the organization, my promise and my commitment to the employees is that there will be no sexual harassment at St. Luke's, and if I know about it, my promise to them is I will make it stop. So we are there to create a work environment that is harassment-free and discrimination-free. So I met with these two women. I met with the director of IT security. They sent me the email messages, and we certainly realized that we needed to do something to honor our commitment to these employees. So the first thing that we had thought of was that we would meet with the police. They listened to the stories of these two women and read the email messages and were quite sympathetic. The director of domestic violence had brought with her little writing tablets or journals. She gave the journals to each one of the two employees and told them to write down anything that they noticed, anything that they observed, anything peculiar or particular. She told them to be careful in walking to and from their car. We assigned a security officer to walk the employees to and from their car regardless of the time of day that they came and left. But pretty much without a name, without an identity of the individual who was sending these email messages, there was nothing they could do. And in the course of our speaking with the police, these email messages continued from this stalker. One of the women, unbeknownst to me or to the director of IT security, responded to the stalker. She sent him a responsive email and asked his identity. He refused, and what he did instead, in response, he sent yet another email message, again identical in content to both of these women. So I am a member of the executive committee of my organization, which consists of the vice presidents and our CEO. And I brought forward to our executive committee a recommendation that we sue John Doe, not knowing who he was. And we're a hospital. We provide patient care. In our 104-year history, we rarely, if ever, sue anyone. So this was a big deal for our hospital to bring this litigation or to consider this as an opportunity to protect our employees. Well, the executive committee discussed it, and the consensus was, or the unanimous decision was, that protecting our employees is a worthy cause, and that if we did not protect our employees from harassment at this point in time, that to make sure that they have a harassment-free work environment, that at some point in time on our road to be a great organization, we would pay dearly for it later. So we made the decision to move forward with this litigation. And what we came up with is several causes of action. The first is trespass to chattels. This stalker had utilized the St. Luke's server and our computers, which are St. Luke's property, to send these email messages to our employees, and he didn't get my consent before he did it. So trespass to chattels was the first of the cause of action. The second, it's intentional interference with economic relations. The emails caused emotional distress to my employees in receiving them, in feeling threatened, in not being able to focus or concentrate on their work. And that is detrimental to the mission of St. Luke's in providing quality care to the people of our region. It interfered with our ability, with St. Luke's ability to maintain a harassment-free work environment. The third cause of action was nuisance, and again that this defendant had interfered with St. Luke's use and enjoyment of its personal property. We'd also asked for a declaratory statement from the judge that the emails were threatening and obscene. So with that, with those causes of action, we filed a complaint against John Doe. Concurrent with the filing of the complaint, we also prepared 2 subpoenas. They were subpoenas duces tecum for deposition, for the deposition of holders of information to be deposed in my office. We sent these 2 subpoenas out to Yahoo and to Cable One. What we had provided each one of these 2 internet service providers with the routing information as to where those emails had come from. And one of the persons in the audience this evening had mentioned that there's a whole lot of information that is either on the footer of the email or is somehow embedded in our servers. And our IT department was able to extract that routing information and put specific information to both Yahoo and to Cable One. So we asked for the identity of the individual who owned the account. Yahoo apparently had the IP address, and Cable One utilized technical facilities that we later found out brought that internet service to John Doe's home. Very shortly, very, very shortly after the subpoenas were served on the registered agents for Yahoo and for Cable One, I received a phone call from someone from the General Counsel's office of Cable One. The attorney who contacted me confirmed that I'd sent the subpoena. He'd confirmed that a complaint had been filed. He confirmed the information in the subpoena regarding the routing number, that it made sense, meaning that that was information that he could track and utilize. And it was more a confirming call to me than any indication that they would move to quash the subpoena. I did tell him that if he were to send me the information by letter, fax, whatever means, as to the identity of John Doe, that he would not have to appear in my office to be deposed. For whatever, if that was persuasive or not, I'll certainly never know. So our conversation was very brief, but again, it was just confirming all that we had done in the course of litigation to get the subpoena to him. Within approximately 24 hours, I received a fax from Cable One. The fax answered every question that we had asked on the subpoena, and the fax, the letter from Cable One identified John Doe. To our surprise, perhaps, this person was a co-worker of the two women. They did not know him. He was infatuated with them. But he worked in the same department as the two people that he had stalked. It then left us with a decision as to what it is that we do with this information. So I had met with our IT director and our director of IT security, and the decision was made to speak with this person. They would not allow me in the room. For whatever that's worth. But the director of IT and our director of IT security called John Doe into the room, and they had a meeting with him. They did not tell him about the litigation. They did not tell him that St. Luke's had filed a complaint or issued a subpoena, but they indicated that we had reason to believe that he had sent these email messages to these two employees. And when confronted, he admitted it. He stated that he did it as a joke and that the two women needed to get a sense of humor, that it was just, you know, a joke, something that you do as part of, you know, being with coworkers, and why couldn't they ignore it? The position of the hospital was that either we accept this behavior that he demonstrated or we don't. And it was very black and white, that either you accept this behavior as appropriate in a work environment or you do not tolerate. You have a zero tolerance for sexual harassment in the workplace. And we informed him that we did not tolerate that behavior at all. And as a result, he was being terminated from employment immediately. What I had later found out is that as a result of unmasking John Doe and discovering his identity, that one of the women filed criminal charges against this individual. I don't know the result of the prosecution because I was not their attorney, or not her attorney, but she did file criminal charges against him for harassment, and the result is unknown to me. Thank you.
And let's bring up our final presenter this evening. Stephen Schroeder is a graduate of the University of Washington and the University of San Diego School of Law. He was a trial attorney and assistant U.S. attorney for the U.S. Department of Justice from 1974 until he retired in 2002. He's prosecuted computer crime since 1992 and was a member of the Department of Justice Computer and Telecommunications Coordinator Program since its inception in 1995. He was a member of the National Working Group that advises the Attorney General on computer crime issues and is a frequent lecturer on computer crime and electronic evidence. He's currently an adjunct professor at Seattle University School of Law, where he teaches computer crime and privacy. He's also taught computer forensics in the Department of Computer Science and Software Engineering at Seattle University. Please welcome Stephen Schroeder.
Good evening, and thank you for coming. I've enjoyed hearing the presenters probably at least as much as you have. What I want to try to do, I've got some legal stuff here that can be a little dry, but I'd like to maybe focus this talk to maybe sum up a bit of what we heard. We've heard about anonymity, we've heard about free speech, and how important they can be in our context. Joelle was right. The Title 47 obscene or harassing telecommunications law has been around for a while. Here it is, we've talked about it, but it kind of helps to look at it. Whoever in interstate or foreign communication makes a telephone call or utilizes a telecommunications device without disclosing his identity and with intent to annoy, abuse, threaten, or harass any person at the called number or who receives the communication shall be punished. All the new law did in 2006 was make clear what most courts had already been doing, and that is applying the statute to email communications, because the internet uses the telecommunications system to a very large extent. Most courts who dealt with the issue had ruled that Title 47, Section 223 did indeed apply to anonymous email harassment. So the change really clarified the law for those few courts who decided that a computer was not a telephone. So under the old statute and under the new statute, the intent must be to harass the person at the called number. That was a defect in the statute I wish they had fixed because it's problematical from a prosecution standpoint. So postings on public bulletin boards would not be covered, for example. Sending communications to coworkers describing the kind of peculiar sexual activities that the victim, in the stalker's view anyway, would be looking for, would not be prohibited. And the communication must be anonymous or pseudonymous and not from an individual who was identified. And the other problem is the one we've already talked about, is an internet-connected computer a telecommunication device. That issue was clarified in the revisions to the law, and that has now been cleared up. Alcaba is an interesting case. The defendant, Baker, exchanged emails with another person expressing a sexual interest in violence against women. And he posted on an alt-sex stories Usenet story describing the torture, rape, and murder of a young woman with whom he had gone to college. He named her. Now, these were private communications. They were not in a public realm. You had to log on to this group in order to get them. And he was charged with making true threats under 875 for the postings and for the emails. The district court dismissed the indictment on the grounds that the email messages were not available publicly and therefore were not communicated to the victim. So they weren't communications. The Court of Appeals, again the Sixth Circuit, found they were not true threats under the First Amendment because the threat must be conveyed for the purpose of furthering some goal through intimidation. For example, extortion to further a political goal or even fostering a prank. So in order to be a true threat, the extortion had to be for furthering some purpose. Now this is a minority view. The other courts have not taken this up. So this raises some interesting questions. Whose reasonable perception of the threatening nature of the communication controls here? Is it the threateners or the victims? Is it an objective test or subjective test? The courts are divided on this. The majority rule is that the threatener state of mind is what controls. Now, does this interpretation of 875, the true threat statute, turn on the requirement that there be a communication? Must there be a communication in order for there to be an actionable threatening, an actionable threat? Hinkson, decided in Idaho. Now, normally we don't get real excited about district court cases even when they're published. But the judge who sat on this case and wrote the opinion was my old friend Dick Tallman, who sits on the Ninth Circuit Court of Appeals. And he had a threat case, and he wanted to act as a trial judge. The indictment in this case, it involved threat against a public official. The indictment did not allege that the threats were communicated. Judge Tallman said there is simply no requirement in the statutory language that the threat be communicated. So the Alcobar ruling that hinged on a lack of communications wouldn't hold water in the Ninth Circuit. Only true threats are criminally actionable. Whether or not it's communicated to the target may help in determining whether it's a true threat, but a communication was not necessary. And then he emphasized that the Ninth Circuit focuses on the maker of the threat and his or her state of mind, and most of these threateners are men, statistically, and is not concerned with whether the listener perceived it as a threat. All right, so communication in the Ninth Circuit. Now, the Planned Parenthood case, I recommend that you look at it. It's a series of wanted posters published publicizing doctors and other healthcare providers who provided abortions. They were pretty chilling. A number of physicians were murdered following the publication of these wanted posters. Civil suit was brought. The Ninth Circuit held that this was protected speech. They weren't true threats. The ACLU filed a brief on behalf of the organization that there were no true threats, and the amicus asked for a ruling requiring evidence that the speaker actually intended to induce fear. But the Ninth Circuit en banc, they took it rehearing, and en banc concluded that the course of conduct in the context in which these wanted posters were published amounted to true threats that were actionable rather than protected advocacy or protected speech. All right, the stalking law. The original statute, which here was basically a travel act. It prohibited travel from one state to another or into a federal enclave or into an Indian reservation with intent to injure or harass. That was amended in 2000 to include communication. And then the final version in 2006 says, whoever with the intent to place a person in another state or Indian country or a federal enclave in reasonable fear of death or serious bodily injury to that person or her immediate family or other protected people, and then uses a communication, including a computer, to engage in a course of conduct that causes substantial emotional distress to that person or places that person in reasonable fear of death shall be punished. So it requires an intent to place another person in fear, reasonable fear of death or serious bodily injury. That's the objective intent that's required. And then it also requires that it have an impact on the intended victim of actually placing them in reasonable fear of death or causing them substantial emotional stress or injury. So I think that's a good, clean statute. I think it passes muster under the First Amendment. And that's, again, a recent amendment that also came out of the Violence Against Women Act. Got less publicity, but to my way of thinking, this is the more important of the two amendments. All right. Finally, last fall, I was privileged to do a series of presentations at a conference in Taipei, Taiwan, and one of the presentations I heard was put on by some folks from Florida State University on their PAPA system. And what it was a interactive computer system that was designed to allow law enforcement, with the consent of a harassment victim, to actually actively monitor the harassment and the threats as the pattern was going on. It's an intriguing concept. If anybody's interested, I have the authors, I have the paper at home. If anybody would like to follow up on this, I found it was an intriguing concept. There are some legal issues in two-party consent states like Washington, but there are exceptions for threats, so interesting concept. Okay?
All right. Thank you, Steve.
It's been a tremendously stimulating evening. thank you to each one of our panelists as I listened to the comments of and the stories and the presentations of Joelle and Elena and Janine and Stephen. It occurred to me that, yes, we are facing tremendously complex issues, and to do just that, to face and hopefully to overcome those issues, we need a great deal of personal courage. We certainly need a lot of legal knowledge. We need a lot of organisational commitment. And this is represented in each of the stories and each of the presentations that we witnessed this evening. So I thank Barbara and I thank Kirk for organising our events. And thank you all, ladies and gentlemen.